Welcome to everyone this evening. I'm Mike Fitz. I'm the Dean of the University of Pennsylvania Law School. And let me say from the very beginning that you shouldn't feel nervous about being called on. And this is exactly like law school classes. Everybody sits in the back and keeps their head down, fearing that something happened. But nobody will be called on this evening unless you raise your hand. This is part of a series that Penn Law Washington seminar series, which really is a forum to consider some of the most pressing, timely issues facing our country and bringing together some of the top people in the country to discuss and focus on it and engage on these topics. Tonight, as you know, with the budget impasse behind us, there is no more pressing. Clearly some emotion on that issue. We're going to discuss voting rights, specifically the future of civil rights and voter access in the wake of the Supreme Court's ruling in Shelby versus Holder. We're fortunate today to have a number of experts on this issue of Shelby, which in a marvelous sense combines a variety of technical legal issues, but obviously has a huge political overlay on top of that. I'll introduce the panelists, give a little background. I should say we're going to have an open conversation up here, but then ultimately we'll open up to the audience for questions and comments. So immediately to my left is Abby Thernstrom, who is Vice Chair of the U.S. Commission on Civil Rights. She's an adjunct scholar at the American Enterprise Institute. She was a senior fellow at the Manhattan Institute from '93 to 2009 and a member of the Massachusetts State Board of Education and serves on the Board of Advisors of the U.S. Election Assistance Commission. She received her PhD from Harvard University. I should note, I don't think she even knew this, but when I was an undergraduate at Harvard University, she was one of my teachers there at Harvard University. I've heard her over a number of years. She's an author of numerous books which have received a number of prizes, including Voting Rights and Wrongs, The Elusive Quest for Racially Fair Elections. Next, to the far right, we have Michael Smerconish, the host of, appropriately entitled, the Michael Smerconish Program on SiriusXM. Michael is a newspaper columnist, author, MSNBC contributor. I should note, for purposes of full disclosure, he's also a Penn Law graduate and was a student of mine when he first started, so there's a certain symmetry between all of this. He's obviously renowned for his radio work. He's also written 5 books, 2 of them New York Times bestsellers, including Morning Drives, Things I Wish I Knew Before I Started Talking. I've read the book. It's very important for deans to read this book. And then he also authors a column in the Philadelphia Inquirer. He's an on-air contributor at MSNBC, and you've probably seen him guest hosting on Hardball for Chris Matthews. And then last, but certainly not least, we have Natasha Korgankar of the NAAC Legal Defense Fund. Natasha joined LDF in 2011 as assistant counsel in the Political Participation Group. Her work includes litigation over voting rights, national voter registration. She's represented African American voters and other voters of color in a number of cases brought under Section 2 and Section 5 of the Voting Rights Act, including Texas v. Holder, in which the court blocked Texas's recent attempt to implement government-issued voter identification. She was also part of the LDF's Shelby v. Holder litigation team. She was part of the team that successfully defended Section 5 in the lower courts. Now, before we begin, I just want to give you, for those of you who are not lawyers, at least a 60-second background on the Voting Rights Act. And for those of you who are lawyers, you can get CLE credit for this minute or two here. But literally, the Voting Rights Act focuses on discrimination in voting. And of course, what we're thinking about today is what constitutes improper discrimination and what's the best way to enforce any prohibition. There, I should note, is a general ban in the Act that bans any standard practice or procedure that results in the denial or abridgment of the right of any citizen to vote on account of race or color. That's a direct enforcement provision, applies across the United States, and litigation can be brought after the fact for any standard practice or procedure which is felt to violate that. What we're opening our discussion on is an oversight procedure which prohibits certain covered jurisdictions from enacting changes in their voter laws or procedures without pre-clearing those procedures with the Attorney General or the District Court in DC. The pre-clearance is to ensure that those changes in procedures are not do not have a racially discriminatory purpose or effect. So in other words, there's a general prohibition against discrimination in voting, but there is a special procedure when certain jurisdictions are changing their standards that they be pre-cleared in Washington. Now, the critical question is what jurisdictions? And Section 4, when the Act was originally passed, the Voting Rights Act, set forth a certain number of covered jurisdictions based on either the fact that they had implemented tests or devices which undermining voting back in the 60s and before, and less than 50% of individuals were either eligible voters were not registered or voted. And there were a certain number of jurisdictions which were covered originally under that, principally in the South. And that particular provision, Section 4, was the subject of ultimately the Supreme Court's decision as to whether or not the judgment of which jurisdictions were going to be subject to this special procedure was appropriate. Obviously, there'd been a judgment based on those criteria when the Act was originally passed. It had been reenacted. Originally, it was only supposed to be for 5 years, this particular provision, but it would be renewed the last time in 2006. The question being in Shelby whether or not the standard for determining which jurisdictions were to be covered by this special pre-clearance procedure was justified years later, and whether Congress, in reenacting the provision, had shown sufficient justification for continuing to cover those jurisdictions. So that is I've discharged at least my legal background in explaining sort of the situation in Shelby. I'd like now to turn to Natasha, who is the real lawyer sitting at the table, who's been litigating these cases, just to sort of set the stage for us in what happened in Shelby versus Holder.
Thank you for having me. I'm very happy to be here. I was, as you said, part of the litigation team that litigated Shelby County versus Holder. And in that case, we represented at the Legal Defense Fund a group of African-American pastors and the lone African-American elected official from Shelby County. All of these gentlemen have lived there their whole lives and are most familiar with what their home is like. And their home, unfortunately, provides a great example of why Section 5 is so important and how Section 4B was really covering the right places. As you said, we won our case in the lower courts. A facial challenge was brought by Shelby County, which is a covered county in Alabama. It's a pretty sleepy place. I've been there a few times. It is about an hour south of Birmingham. And the facial challenge basically said that Section 5 and Section 4B of the Voting Rights Act are unconstitutional on their face, that they should be declared unconstitutional and therefore invalid. My colleague argued the case in the Supreme Court, and the pith of the argument from Shelby County, the other side, was basically that Section 4B was outdated, that it wasn't reaching the places in the United States that had the worst histories and the worst records of discrimination in voting, and that Section 4B and Section 5 as well should be invalidated. The pith of our case was really that history, both old and contemporary, that is within the reauthorization period from 2006 until now, as well as the previous period between 1982 and 2006, showed that the histories of these places that have been covered by Section 4B are indeed quite different from other places. Of course, racial discrimination, unfortunately, is not localized to one region or to any one place in the country. It's everywhere. But that the history in these places, many of which were in the Deep South, but not all, Alaska is covered because of its persistent discrimination against, or was covered rather, against Native voters, South Dakota as well for the same reason, Arizona for its discrimination against Latino voters. They basically said, this act isn't getting the right place. We basically said that our clients know, and the record shows us, that in fact the Voting Rights Act and Section 4B was getting to the right places. It was getting to places where racial discrimination not only existed, but was adaptive and persistent and really just kept changing forms. And that was really the beauty, or remains the beauty of Section 5. Once we get a new Section 4B, we'll see it come to life again. It was specifically enacted not to punish the South, not as a punitive measure, but really because those places that were covered had a pattern of changing their voting practices in a way that outpaced federal court litigation. So what that means is that no sooner had a voting change that discriminated against African Americans or other voters of color been declared unconstitutional by a federal court, then outside of the courthouse doors, the laws were changing, and federal court litigation basically couldn't keep up with those changes.
So that was your litigation strategy, and making those arguments to the court. The court didn't, at least 5 members of the court didn't agree. What was the reason they didn't agree?
Well, it's hard.
What did they say the reason they didn't agree?
Well, the court didn't really deal with what was the bulk of our brief in particular, which is what the reauthorization record showed. It showed that Congress had carefully considered whether to reauthorize the Voting Rights Act in 2006. It heard testimony from over 90 people from all sides of the issue. It amassed a record of 15,000 pages, I believe, and held, I believe, 21 hearings when it considered that. The long and short of it is that the decision said that 4B wasn't contemporary, that it needed to have been updated, in short, and that it wasn't actually reaching places where current needs justified this kind of pre-clearance structure.
So, Abby, you've written really almost as much as anybody about the Voting Rights Act.
You can offer condolences.
And made certain predictions about how you thought the court would come down in Shelby. And turned out you were right, and wrote a piece in the Wall Street Journal after, which had the title, though, as we know, you probably didn't write the title, that was probably the Wall Street Journal, entitled Vindication. And generally you viewed, and I'll let you follow up, but you viewed in some sense the decision as a vindication of the Voting Rights Act.
I celebrated the decision, absolutely. Let me say, can I say a couple of other things first in response to you and Natasha? You are perfectly right that the legislation in 1965 was all about discrimination, egregious violations of the 15th Amendment. But over time, there became no agreed on definition of the meaning of what electoral discrimination meant. And Justice O'Connor at one point said, complaining, you know, we don't have consensus on what electoral discrimination means. And the Voting Rights Act in 1965 was a perfect piece of legislation. Now I can't think of another piece of legislation in the history of Congress that I think was perfect, but that was. But it changed over time and became something very, very different than what it was in 65. The jurisdictions that ended up in, as it were, a penalty box, that is, yes, any changes had to be pre-cleared, and the burden of proof was on them to prove non-discrimination. And of course, it matters a lot in law where the burden of proof lies. Now, they deserved to have a very heavy federal hand telling them what they could do and not do in the way of electoral changes. They had earned that with a long history of disfranchisement. And the statistical formula, which you did give, that was arrived at, was reverse engineered. That is, those who drafted the legislation knew which states were disfranchising blacks. They could just look at the numbers. Below 50% total turnout, black and white, well, that was because of black disfranchisement. And so they figured out what states needed to be covered, and they devised a formula which perfectly hit those states. Beautifully done. And as I said, those states, I mean, Justice Hugo Black did complain that states were having to beg the federal government when they wanted to change laws, and electoral matters are supposed to be a matter of state prerogative. But Justice Black, who of course was from the South, was an Alabaman, came to the matter with dirty hands simply because he was Southern. Natasha mentioned the coverage of Alaska and Arizona, but they weren't covered because they had any kind of history of electoral discrimination comparable to any place in the Deep South that was covered by the original trigger. The reason they were covered is because the definition of a literacy test was changed to include English-only ballots. And that is very important, not to confuse places that were like Mississippi. Mississippi had 6.7% of eligible blacks registered in 1965. You know, we're not talking here about massive disfranchisement when we look at Alaska or Arizona or 3 boroughs in New York with the other 2 not covered. There was never any kind of real discrimination in New York City. Blacks have been participating and getting elected in that city for a very long time. And then my last comment on the kind of run-up to this. 2006 carefully considered the district court carefully considered that congressional record. I regard that congressional record as just an anecdote dump. It was completely unimpressive in my view. And I don't think that the Supreme Court should have relied on it in making its decision.
Just to sort of put this in context, the issue, as you say, is should certain jurisdictions be in the penalty box? And the basis of being in the penalty box is a particular history of discrimination in voting. Everyone agrees that in the 60s, these jurisdictions clearly had committed horrendous discrimination. The act had been renewed a number of times. The issue now in 2013, based on the Congress's reenactment in 2006, is whether there was a continuing level of showing of discrimination to justify being, as you say, in the penalty box. And I guess I should just turn it back to Natasha, and then we'll go over to Michael for the political overlay on all of this. But Natasha, you would agree that in 2006, these jurisdictions were not like it was in 65 or 70. So the question is, what do you think the appropriate standard should be for putting these jurisdictions in a separate category?
Well, I think there's two issues there. First, I'll say that yes, I of course agree that what was happening on the ground in the most recent authorization period isn't the same as what the reality was in 1965. Of course that's true, and thankfully that is the case. But we don't diminish our progress by demanding more of it. I reject the premise that just because we believe that we still need the Voting Rights Act means that we're not actually appreciating the way that things have changed. Instead, I would say that the second thing I would point out is that this is just as much about whether Congress has the authority under the 15th Amendment to have considered that extensive record before it, and to have made a decision that based on the record before it, it is reasonable. It makes sense for us to reauthorize this provision and to have it last for another designated period of time, after which Congress would have, of course, considered again whether we still needed it, and perhaps in the next reauthorization period after 2006, Congress would have said, we have come to a point where we don't need it anymore. But Section 2 of the 15th Amendment gives Congress the power to enact legislation to block racial discrimination in voting. And Congress did that.
Right. Just to give the sort of a 30-second constitutional overlay here, the dissent, Justice Ginsburg points out that Congress is specifically empowered to enforce the 15th Amendment. There's broad deference to congressional judgments in this case, and therefore, as a structural matter, the court should be referring to a congressional judgment in a situation like this about the enforcement of the 15th Amendment.
If I may, I'd also just like to point out something that's of course clear but bears mentioning, which is that this case and this issue is about the intersection of two of the most fundamental rights we have, which is the right, of course, to vote and to be free of racial discrimination. So Congress, I think, was entitled to a considerable amount of deference, and even had it not been, the record that it amassed was enormous. And Dr. Thernstrom, I think that you actually participated in that record, if I'm not mistaken.
I'm not sure I did. I mean, I participated. I participated in hearings before Congress, but I don't think I participated in those hearings. And I have always thought that it was an anecdote dump, and that the plural of anecdotes is not data. And that's what I'm interested in.
I mean, many
data.
of these anecdotes are our clients' stories.
Yeah, I know their stories.
And
that doesn't wash with me. I'm a social scientist.
Let me just sort of a quick question, then we'll get over to Mike. But what sort of evidence do you think would have justified?
Well, look, I mean, I don't understand people denying a fundamental fact, which is we are a racially transformed nation since 1965, beyond anybody's imagination at that time. And wherever you look, that's true. I mean, my husband and I just co-authored a piece in National Review on the degree of racial progress when it comes to integration. Wherever you look, there's an amazing picture of an integrated society that we could never have imagined almost 50 years ago.
So
I mean, blacks are part of the American political process. It was David Souter who, after all, who said, you know, isn't it time for them to pull, however that quote, haul on their own? I mean, they're not helpless anymore. And I frankly think it's demeaning and patronizing to portray black voters and black elected officials as helpless in terms of organizing the vote, getting out the vote, and making sure the franchise works for black voters.
okay, so you know, one of the sort of we can talk about whether Congress met its standard, whether there should be deference to state judgments, but in a very fundamental way, what this case turns on is the sense of where the United States sits racially today. It clearly is not where it was in 1965, but there's a separate question about where are we
And I think there's great news.
Michael, as somebody who spends huge amounts of time listening to America discuss racial issues, what's your sense about how the country's changed or not changed?
Well, I like to say that I answer the phone for a living, because that's truly what I do. I take telephone calls from people all across the country, and I do it for 15 hours a week. I respectfully don't accept Dr. Thernstrom's last statement, because to me it suggests an either-or, that, well, we've made progress, and with an African-American president and with Mississippi leading the league in voter turnout, you know, you can't say we haven't made progress, but that kind of presupposes that therefore we no longer need the Voting Rights Act protections, and I don't buy into that. The easy solution would be for Congress to look at the most recent data from 2012 and rely on it, but Congress isn't going to do that. And it's fortuitous that we would be here, I think, tonight, because you look at what happened last night. In literally the 11th hour, still faced with certain defeat, 144 Republican members of the House wanted to go down with that ship. And to me, that speaks to their perception of conviction and unwillingness to compromise. I bring that up because I have zero faith that the Congress is willing to deal with this hot potato. You know, there's a very naive perception among some that you look at that voting outcome in 2006 and you say, well, unanimity in the Senate, 30-some votes in opposition in the House, everybody else on board. My God, how much could have changed since 2006? Well, in the light of day, nobody wanted to be the candidate who could later be accused of having voted against the Voting Rights Act. You can imagine how that would play. My opponent voted against the Voting Rights Act. Nobody was willing to endure that. But behind closed doors, when sausage needs to get made, they're going to take every opportunity they can to torpedo this, and I maintain it never comes up for a vote. So I have zero faith in the Congress to deal with this issue. And when I look at the politics of it, I separate it between Washington politics and the nation at large. To me, that's the bad news. The good news is that there will be, and I think there already have been, political ramifications in not dealing with this, and they're twofold. The obvious is to say, well, this energizes the minority base. This energized African-American voters in 2012 who, as 13% of the electorate, outperformed statistically their standing. But there's a second role that, to answer your question, Dean, the one that I think I'm best plugged in on. I think that it's simplistic to say, well, in the battle between voter suppression and ballot security, take your pick, it's the African-American vote that's going to be impacted. No. I think that many Americans are paying attention to this and wanting to see fairness. I like to say that the only people that I am aware of who see the world entirely through liberal or conservative lenses are fellow radio hosts and cable television presenters. Because when I am leading my real, normal existence, pumping gas, picking the kids up, 3 of them in high school right now, or doing the grocery shopping at home in Philly, people will engage me in conversation. And the people who engage me in conversation don't look or sound anything like those caricatures on radio or TV. They're a mixed bag. They're often fiscally conservative, liberally social, and there are a whole host of issues that they haven't figured out. And anecdotally, what I've noticed during the course of my adult life was just proven this week in Esquire magazine. And if you haven't read it, you must. There's a model on the cover, but the most compelling thing about the magazine is their analysis of the centrist movement in this country. 51% of the United States centrist. More than the left, more than the right, more than the left and right combined. And I bring this up in answer to your question because it's those centrists who I think are monitoring this situation. And if they believe that North Carolina and Texas and even Pennsylvania are treating minorities unfairly, even though there's an African-American president, and even though Mississippi is voting at a record number, they'll be hell to pay at the ballot box. I can't back it up with data, but I think that it was a factor in the 2012 election. I think the Obama candidacy was assisted by centrists who looked at what was going on in some of these states and were repulsed by it.
So, if you're right, then ultimately, after one or two elections, we will start to see representatives in Washington sensitive to the centrist movement. I mean, is that...
Well, not in the House.
Not in the House.
Not in the House because, as Nate Silver documented so well at the 538 blog, you go back to 1992, and we had 100 of the 435 congressional districts in the country that were legitimately in play in a presidential year, meaning they were decided within 5 percentage points. We're down to 35. So bad behavior, both far left and far right, gets rewarded. And that's really the issue. So I would like to tell you that I think that there'll be a cleansing of the House. I don't see it. I think you'll see more immediate ramifications in the Senate, but it'll impact the national vote. You might not see what I'm talking about in 2014, but I think you will in 2016 if states continue to erect these obstacles. So as long as I've already extended myself this far, I'll just finish with one additional thought, which is to say...
And just tell us at the end who will be president in 2016.
I am not a believer in coincidence. I don't believe, and I'm well-versed on the Indiana decision that Judge Posner now regrets. I don't believe that coincidentally all of these states mobilized with so-called ballot security in mind at the time that the nation was electing and then re-electing the first African-American president. It's just, I don't see it that way. Never on my watch, and I've been paying attention for 30 years, has there been anything like this afoot. I also should say that I think there's nothing unreasonable about asking for an identification card at a ballot booth, so long as you take into account the type of identification that folks who live in that particular community are inclined to possess. Now I know I've overstayed my soundbite. Normally, in my business, we would say we're going to commercial break right now.
As a law student, Michael would do the same thing. He'd dominate the floor.
No, that's not true.
Probably true of all four of us, even though I'm not a lawyer.
You're an honorary lawyer, so...
I'm an honorary lawyer. I've written on nothing but law.
Just sort of to back up, just to sort of encapsulate what you're saying, what you're indicating over the short run is it really matters what a court does in these situations because the political process is sufficiently stalemated that it will not be able to reach compromises or intervene. So in this particular case, you have the court, you have Congress reaching what appears from the outside to be a huge consensus in 2006 on the act, signed by President Bush. Court, you would think that whatever the court did, that Congress would come back to it. And your view is, at this moment, it's so divided that we're not going to see the political process coming back.
Right. I think it will never happen. But the real political payback will come when voters... You know what I think really mattered? I think it mattered when Americans looked at those lines on Election Day in Florida. I think that those images were sort of seared in many of our minds, and that there's something fundamentally unfair about people being in the habit or practice of voting early, having the opportunity on weekends and so forth, and then having that taken away. I know others will say, well, you still can go out and vote on Tuesday, et cetera, but when it's your custom or your habit and then you're denied that opportunity, I think that's unfairness in the minds of many. And so I'm suggesting that Congress won't deal, but that if this isn't addressed and if states continue to be, I'll say, aggressive, there will be a political penalty paid by the party motivated in that direction.
Well, Michael, can you think, or do you know anybody who can answer this question? Can you think of a formula that would reestablish preclearance for whatever places you think should be under preclearance? It can be still Mississippi, it can be Ohio, it can be whatever. But the fact is, one of the reasons Congress won't act, and I agree with you on that, is because nobody can come up with a formula that would work. And when I say nobody, I mean none of the leading voting rights scholars, and I would include in that group, for instance, Pildes or Sam Issacara, very thoughtful people. They don't have an answer to what Congress could do that would make sense. One other point. Dean, you said huge consensus in 2006. Yeah, of course. Republicans are utterly terrified of being called racist. And that, it was the R word that would have been, as you partially said, that would have immediately been dragged out and used against anybody who questioned the reauthorization in 2006. Everybody was hiding under their chairs for understandable reason. There is no worse label that can be put on anybody in America today than racist or closet racist or some variation on that.
I want to go back to your first point, which is what a 2006 preclearance process should look like. If you sort of throw out the Voting Rights Act, and let's suppose Michael is correct that in 2016 there's sort of an epiphany in our political process, and they move to look at this question. What do you think an appropriate standard should be for preclearance in the United States? Natasha.
And one that is politically acceptable to the states who would be newly covered.
Well, let's just get to the we'll get to perfection, we'll get to politics after that. But what do you think would be, if I know you're not speaking for the Legal Defense Fund, but just what would an ideal system look like today in 2013?
I should say I'm not a legislative expert, so I'm not really sure what would or wouldn't get passed. And I thought that Section 4B before made a lot of sense for the reasons that I explained before. I will say, though, that one of the most important things that I think relevant or would be relevant to the creation of a new 4B would be to, without a doubt, look not only at voter registration, but other types of what people call second generation types of voting barriers. So first generation barriers are generally vote denial, and that's usually reflected in low voter registration rates. But I think considering things like voter ID might make sense, considering things like Michael said, like long lines, inability to get to the polls, or new kinds of suppression techniques that we've seen.
Right. Yeah, I mean, so there are sort of two separate issues here, as I said from the beginning. One is what constitutes discrimination. There was an easy time, it was overt, and there were tests, literacy tests, whatever, poll taxes that were used to prevent people from voting. We're now in an era of a different type of issues, voter ID, as people mentioned, sort of the selection of voting places. And that, of course, is sort of the legal issue. Then there's the structural issue of preclearance. I guess we'll pull that aside because people don't want to talk about what districts should be covered. Voter ID, it's the issue on the front of the newspapers at this point. Should that, in a sense, Natasha, I know you've been involved in a lot of litigation over voter ID. Should voter IDs be held illegal under the Voting Rights Act?
I would say as a general statement, no. I don't think that a voter ID law in general is necessarily violative of the Voting Rights Act. In fact, Texas, where we have a case we won under Section 5, we're able to block Texas voter ID law, and subsequent to the Shelby County decision that was vacated, we're now challenging it under Section 2. Texas had a voter ID law before this new one that we've been challenging through Section 5 and now Section 2 of the Voting Rights Act. It was a voter ID law that wasn't exclusive. It didn't disfranchise young people, people of color, and the elderly. And it wasn't as strict as the one that passed subsequent to it. So I'd say no, in general, is voter ID something that's unconstitutional or that violates the Voting Rights Act? It isn't, but all of these new voter ID laws that we've seen in the past 2 years or so are very, very restrictive, and many of them are, in fact, violative of the Voting Rights Act and of the Constitution. Texas is being one of them.
Natasha knows far better than I, but I think Texas is an illustration of what I was talking about, where a gun permit allows you to vote and a college ID does not. And I just think that to me is a clear indication of trying to single out the younger voter because you don't want them voting, and you do want anybody in that state who's got a gun permit. I think it's hard to justify relying on 40-year-old data for the way in which you would currently apply the Voting Rights Act. So at a minimum, there's got to be an update done on the process. I would go even further, though. You know, Pennsylvania's not on that list, and I didn't like the way the Commonwealth was behaving in 2011 and into the 2012 race. I think we need a national
Pre-clearance. Should we have a national pre-clearance?
I think we need a national Voting Rights Act, and what I would, and I know some...
Good luck, Michael.
Well,
That's
nice to...
dead on arrival.
But it would, I recognize you can't infringe upon states' rights, but at least with regard to a federal ballot, at least with regard to congressional, senatorial, and presidential race, some standards of uniformity could apply. Gone would be butterfly ballots. The idea of you needing to vote in your particular precinct. I mean, my God, we do everything online in this country except vote. And I think that we're looking at this backwards. The objective ought to be to expand the pool of those who are participating in our democracy, ensuring some level of ballot security, of course. But every one of these conversations seems like instead it has an alternative goal, which is to narrow the pool for political purposes.
Can I say something, Michael, on the voter ID thing? Look, I'm in total agreement, both with Natasha and Michael, that voter IDs should be easy to get. We should make sure that nobody is stopped from voting because they can't get a voter ID. So, you know, there are many ways to make them very accessible. And of course we should expand the pool. But in some fundamental way, I don't understand this issue. To get into the Reagan building today, I had to show a federally issued ID. When I was last on a program at NPR debating voter ID, that was their old building. I don't know about the current one. I couldn't get to the studio up many floors. I couldn't get to the elevator and up to the studio without showing a government-issued ID. You can't get in a building in Washington or a building in New York City either without some kind of federally issued, government-issued ID. And the American public, of course, is solidly behind ID. So, look, I don't want voter ID laws to stop people from voting, and I want them readily accessible. But the issue of, people getting hysterical about IDs when, people can't get, they can't get a bank account without having an ID, and if they can't get a bank account, they can't get their Social Security check or their welfare check. I mean, it's ubiquitous, the need for IDs. And, so I think the point is only to make sure people can get them.
We will be opening this up to the audience in a second, but I just wanted, in light of Abby's comments, I wanted to turn it back to Natasha. You've been involved and are looking at the sort of the next generation of litigation on voting rights. Obviously, on the front page is voter ID. What other areas do you think are going to be topics of litigation going forward?
Well, I think that if we turn to North Carolina and look at their omnibus anti-voter law, it's really easy to see. It's a lot of things that everyone has actually heard about that we've been seeing. In addition to the voter ID laws, it is cutting back, as Michael mentioned earlier, the early voting period, changing polling places. In Texas, I know there have been a few examples of changing what were formerly elected positions to appointed positions. It sounds out of control to me to tell you that that's happening. It is on the ground in Beaumont, Texas, in Galveston County. So I think the next generation is a lot of stuff, unfortunately, that we've read about before or that we've been reading about for the past few years. It's just coming in spades, and that's the difference. Without Section 5 there to block these laws, local jurisdictions as well as states are just allowed to pass things that they may have been holding for a while because they knew it would be denied pre-clearance, or in the case of Galveston County, just re-legislating laws that were previously denied pre-clearance.
Can you identify changes that literally are look post-Shelby? In other words, can you see sort of, at least in the number of things occurring before and after the decision came down?
I mean, identify specific changes that were clearly animated by the laws of...
Well, at least the change in the decision, yeah. Well, it may not be a racial animus that produced them, but clearly the absence of a pre-clearance procedure could lead to different movements in terms of changes in procedures.
Well, I just read an article today about the Beaumont School District in Texas. It's a city, I guess it's got a population of about 150,000 people, way out in East Texas, almost Louisiana. They have tried to restructure their school board to get rid of a number of elected positions, make the school board smaller, thereby basically eliminating a number of positions that were previously majority minority, and where the black community there was able to elect candidates of their choice. I think Texas's voter ID law is not actually dissimilar from what you're saying. We had a federal court decision from the Section 5 court that said there's a lot of evidence that this could be intentional discrimination, but it didn't actually have to reach that conclusion to block the law. And not 12 hours after we got the bad decision in Shelby County, Greg Abbott was tweeting that voter ID was back on immediately before the court had even vacated its decision with respect to the Section 5 decision. So although that's not a different law, I think that shows the mindset of the state. And as I mentioned, Galveston, the city of Galveston, is thinking about redistricting in such a way that eliminates majority-minority districts by reducing the number of elected officials on that city council. And that would eliminate
Are they going to at-large voting?
I think they're still considering it. I don't know that they're actually going directly to at-large yet. I think that they're considering a multi-member district and some combination of single-member districts.
I mean, my problem with your point there is that there are lots of forms of, there are lots of electoral arrangements that square with democratic government, including at-large voting, which has its virtues, including multi-member districts, and to have labeled them, and this is what has happened over the years, to have labeled them all discriminatory is, I think, doesn't square with our constitutional structure, nor is it correct.
just for those of you in the audience who are not sort of immersed in this particular debate, obviously one issue is whether people make it to the ballot box, whether they're ID, poll tax, literacy tests, other. The issue of voter dilution is when the structure of the political process is made in a certain way as to reduce the likelihood of certain people being elected. As you know, for example, if you have single-member districts, it's frequently thought that there's more ability for minorities to be elected because they'll be concentrated in narrow areas. But if you have a sort of one representative, it makes it less able. And the question is whether that constitutes discrimination in the structuring of the system. It's obviously a new set of issues.
Well, yes, but the people who are elected at large are you know, all voters are their constituents instead of a little enclave.
But if a community doesn't have the ability to elect its candidate of choice, but is a substantial
Oh, well, wait a
portion
minute.
of
In other words,
voters-
there isn't a reserved seat for a black or Hispanic. Is that what the Voting Rights Act is supposed to be about? Quotas for blacks and Hispanics?
Absolutely not. It's about people of color being able to cast our ballots and to have our
Nobody's
ballots
stopping people
count.
from casting ballots.
Well, voter ID law does stop a lot of
Well,
people
okay,
from
you've
being able to
moved
cast their
from
ballots.
at-large voting to voter ID laws.
Which was my point, a very simple point, which was simply we're talking of two types of issues. One is whether minorities are going to be able to get into the voting booth. The second question is how their votes are counted, how they're represented, and that's obviously a different set of questions. I'm not saying I'm not saying how you resolve those questions, but it's a different set.
The at-large voting instituted in the progressive era was considered good government, and it still has its virtues, and it's been tossed out as discriminatory on its face. I think the argument is very weak. We're also talking about the question of disparate impact and intentional discrimination. And there are those of us, evil that we are, who think discrimination means intentional discrimination, and disparate impact is not discrimination.
Right, which, again, this is the sort of the second generation of discrimination issues. What constitutes discrimination? And it sits behind these procedural issues of pre-clearance about what the substantive issue should be. But I don't want the panel to completely dominate this. There were questions out here. Yes, sir.
I'm intrigued, Dr. Thernstrom, by your comment about the anecdote dump for legislation. One of my favorite lines over the years is the plural of anecdote is not data. But as a former congressional staffer, it struck me that if these data are right from what you were citing, the 21 hearings, the 15,000 pages of testimony, that is more evidence in the legislative record than 99% of the laws on the books, which if I were to take what you were saying at face value, it seems to me you're saying in effect 99% of the laws that we have in the country would flunk that test and perhaps be unconstitutional. I find that a very, very hard thing to swallow. Most legislation that goes up has maybe a day or a half day of hearing, and it's all anecdotes. So I'd be curious to hear your response to that. But I did want to raise one other thing, because Michael, you said 40-year-old data, and it's my understanding, and Tasha, I hope you would clear that up, that the 21 hearings and the 15,000 pages of testimony were current with respect to the 2006 law. Do I misunderstand that?
I think that what Michael was saying is that the initial coverage formula was based upon voter registration data from the 60s.
But the data are not 40 years old. The data
Right, the data in the reauthorization record. That's correct. That would have been from the time between 1982 and 2006.
Look, when you look at the data today on registration and turnout in those covered jurisdictions, I mean, it's a time for celebration. And there was basically, in 2006, they did not rely on data. They relied on anecdotes. And look, in terms of your point about legislation that has passed, yeah, well, I'm very cynical about how legislation gets through Congress and how many members of Congress actually read the bills they vote on. So, okay, you know, what they knew in 2006 was they couldn't politically afford to oppose the reauthorization of the Voting Rights Act. I understand that because we live, as I said, in a country where the worst thing you can be called is some sort of racist or closet racist or whatever. Politicians aren't going to risk that, and they didn't.
Dean, can I just...
Yeah, Mike.
The data that I would most like to see would be the data of the voter fraud that is so widespread that every one of these states... And in thinking a lot about this, the data that I think is most relevant is the following. I want to say this clearly, in 1988, George Herbert Walker Bush, running against Michael Dukakis, got 59% of the white vote. That's precisely the same percentage of the white vote that Mitt Romney captured in 2012. In '88, getting that percentage of the white vote meant that George Herbert Walker Bush had in excess of 400 electoral votes. I want to say 426, don't hold me to it, but this I know. It was twice as many as Romney obtained in the most recent cycle. And in a nutshell, what that illustrates for me are the changing demographics of the country, that 59% in '88 ensured your victory. I think it was a 7 million popular vote margin for Bush. Romney ends up losing by 4.7, 4.8 million to Obama. And I think, frankly, it is awareness of those numbers and how the nation's composition is changing that is driving this whole issue.
Well, you know, I agree that there are a lot of conservative Republicans who are hysterical about voter fraud, and I think in a very misplaced way, because if you get on an election, the election listserv that Rick Hassan runs, where there's this huge discussion of election law issues, there's general consensus that fraud is not a big issue. And so I think you're focusing on the wrong issue. And I say that, I am a Republican, but I think the conservative Republicans are out to lunch in screaming about voter fraud.
Dr. Thernstrom, I don't think the hysteria has anything to do with voter fraud. I was trying to argue that the hysteria has more to do with the perception of the changing dynamics of the country and how that doesn't suit the political objectives of those who now want to erect these barriers.
What just to back up, in all of these cases, there are issues about discrimination in voting and differential impact and so on. But it's also clear there are huge political implications about who gets elected. And now this entire debate over the Voting Rights Act overlaid on top of it is also a perception that these decisions will have impact on who gets elected. In voter ID, what you're suggesting is voter ID has a differential impact on certain voters and the motivation behind it.
Deliberately so.
Right.
Yeah, that is what I'm saying.
Yeah, right. Sorry.
And I disagree on that, of course.
Okay, sure.
It's okay, go ahead.
No, go on.
I had a quick comment and then a question. The comment is with regard to voter ID laws. There was reference made earlier to the fact that federally issued IDs are ubiquitous and that we need them to get into the Ronald Reagan building and the NPR building. My response to that would be that those aren't federal rights. We don't have a federal right to go into the NPR building or the Ronald Reagan building. We have a federal right to vote. So requiring an ID law for something that is a federal right is way different than needing an ID to get on an airport or to get into a federal building. So I think those are really separate issues. My question though, because I'm not totally sure what my position is about the Voting Rights Act, was that isn't it a good thing that the Supreme Court has allowed for the possibility that more states might be able to be included in the pre-clearance process, in spite of the impotence of Congress or the difficulty in getting things passed? Isn't it a good thing that the Supreme Court has opened the door to possibly allow for even more states to be included in the federal pre-clearance by requiring that there's now a new assessment of the qualifications for pre-clearance?
Yeah, let me just, I don't think the Supreme Court's decision enabled Congress to necessarily revisit the question. Congress always could have revisited the question if they had wanted to. What the Supreme Court decision did was eliminate the existing pre-clearance process so that in the absence of congressional action, there would be no process. So I'm not sure, whatever your views, your underlying views, I don't think you would view the Supreme Court decision as, in a sense, opening up the possibility for a broader expansion. Yeah. Oh, I'm sorry.
Well, I was just going to say, look, Mark Rush, who teaches government at Harvard, has just on this election listserv sent a note around to everybody saying, look, there is no democracy in the entire world that does not demand voter ID. We're the only one that is, in which it's controversial. He may be wrong, but that's what he says.
Let me ask you this question. And then I'll turn this to Natasha. Let's suppose, for factual purposes, there really was we knew there was no voter fraud, or just infinitesimal. But we knew that the requirement of an ID...
Relatively small, let's put it that way.
No, this is one of these law professor hypotheticals. Imagine this world. But for purposes, I don't want to argue about what the data is.
Yeah, don't argue on the voter fraud because you'll be in the weeds.
But the point is, if there really was not any real substantial voter fraud, and if voter ID was seen to really be an impediment for citizens voting, would there be a justification, in your view, for voter ID laws? Even though you need a voter ID to get into the Reagan building.
I don't want there to be, I'm sorry, I've got an old cold. This is not contaminating anybody near me. I'm sorry, the question again is, would a voter, if it's stopped...
Is this really about fraud? And if we could show, or we didn't think there was fraud, would there be any reason to require voter ID in your view?
Well, I don't want fraud, and if there is a link between fraud and voter IDs, I don't want fraud, stopping fraud trumps.
Right.
So I don't think you and I are in disagreement on that.
Okay, let me just, to move on, Natasha, what if it were shown there was substantial amount of voter fraud? Would that change your view about voter IDs?
I think that if there were any evidence, which of course there isn't, of substantial voter fraud, then yes, it might make sense to consider ways to combat that voter fraud, that in-person voter fraud.
Which practically doesn't exist. It's hard to do that.
I'm sorry.
Hard to...
It's hard, impersonating somebody else and going to a polling place is very hard to do.
That's absolutely right. And that's why we don't need these voter ID laws. And that's why I think that when you look at, and Texas is the state that I'm the most familiar with because of the litigation there, when you look at what's happening there, it's just like Michael has said, there's a changing complexion in Texas in particular. The electorate is changing. The demographics are changing, and Texas is a place where this is happening, I think, faster than in other places, and it's more visible. If you look at the legislative history of Texas's voter ID law, it is rife with indicia of intentional discrimination, departing from the normal procedures for that state's legislature. That happened many times. It's in the record for the Section 5 case, and meeting without minority legislatures present, rejecting any ameliorative amendments that could have made that law something that Texans actually could have met and could have been able to vote under, adding student IDs rather to the list, making it actually easy to get free IDs regardless of whether you have any of the expensive underlying documents. If we could do those things, and if there were voter fraud that occurred in person, then maybe there would be some kind of voter ID law that would work. But what we know is that the voter ID laws that are out there are not those laws. They're not the ones that would work, and they are indeed not responding to a problem that actually exists.
Question? Yeah. Question?
Thank you. I came here tonight expecting a serious discussion about a very serious topic. And I am dismayed that the argument that is used to support the Supreme Court decision is that the incredible congressional record, which I agree, I also was a congressional staffer, 23 days of hearings is an extraordinary commitment of congressional time. 15,000 pages of testimony is an extraordinary amount of testimony. And I am just flabbergasted that the entire record is dismissed so cavalierly and with no analysis or any justification. It's just, I don't like it. It doesn't support, it doesn't meet my standards as a social scientist. I'm obviously speaking to your comments.
Yeah, but I've read that entire
Allow me to
record
finish,
also.
please, ma'am.
Sure. I'm just telling you,
I don't care right now. I am speaking.
Fine.
Thank you. Nobody, and the Constitution does not require a level of whatever you want to call it in terms of meeting your social scientist requirements before you pass laws. We have a lot of laws, and I am not one that will support very many of those, and I am not one that will support a whole lot of the congressional effort. But I am absolutely astounded at the extraordinarily cavalier treatment of such an incredibly important, vibrant issue. That's one point. The second point I want to say is we haven't talked very much about gerrymandering. And to me, gerrymandering is what has gotten us into this mess. And when we say, what can we do about it? Well, gerrymandering to me is the whole issue of what we can and should be doing, and dealing with something that is a little bit outside what the Constitution, because it does affect the ratio that the Constitution established. So I think there are real issues there. And I wanted to just ask you, ma'am, I don't know your name, Thornstrom.
Okay. Could we?
Just one last thing, is I understand your support for at-large candidates and elections now. I just want to point out that I believe in a couple of years we're going to find that people who are taking the support for at-large elections are going to be arguing for single-member districts because they will find that they are no longer in the majority. Thank you.
Okay, let me answer you. First place, it was not a cavalier statement. I have read that congressional record myself very carefully, and you will see my analysis of it if you want to pick up my most recent book, my second book on voting rights, called Voting Rights and Wrongs, The Elusive Quest for Racially Fair Districting.
Okay.
I didn't say it didn't matter. I'm saying I've read through the congressional record myself. There was nothing cavalier about my statement.
Okay.
Okay. Second, I don't support at-large voting. I'm just saying they are one method of voting. Lots of methods of voting are legitimate in a democracy, and that is one of them. But in didn't say I supported them. I don't have a position on whether at-large voting it's got its virtues, it's got its downsides. The drive for single-member districts, which became mandatory as a remedy for discrimination under the Voting Rights Act, which worked to protect black candidates from white competition, they were absolutely necessary if we were going to get black faces in office. And they were necessary, I think, until quite late in the game. I support that kind of race-conscious gerrymandering in order to promote black office holding. So, my position is not single-member districts are good as such. At-large voting is good or bad as such. It wasn't what I was arguing. As for gerrymandering, well, racial gerrymandering came to be mandated in the enforcement of the Voting Rights Act. It's what Chief Justice Roberts called divvying up by race, and it's which was very troubling to him.
We'll take a couple more, but Michael, we were talking before about the change in the political atmosphere in Washington and the causes of that. One of the issues that was raised is the whole redistricting.
Sure. I think there are three others.
Well, just sort of to bring this to broader, to what extent do you think redistricting and the whole process is the cause, and what else do you think is the cause of it?
I think that gerrymandering would be close to the top of my list. There would be three other factors driving polarization, not necessarily in the Voting Rights Act. One of them is the role of the media. There's no coincidence that 30 years ago, 60% of the Senate was comprised of moderates. You go back to Ronald Reagan's watch, and you had something in the Senate called the Wednesday Lunch Club. Bob Packwood, Alan Simpson, Nancy Kassebaum, Arlen Specter. It was like John Hines, 24 Republican moderates gone. And the National Journal, with this annual survey that they do, has documented the demise of the center, both in the House and in the Senate. Great data, nonpartisan, straight on. What else has taken place in 30 years? The rise of AM talk radio and cable television news that plays to the extremes and not to the center. And I don't think that's a coincidence. I think that too many who are elected officials take too many of their cues from the polarized media. So I blame gerrymandering, hyperpartisan districts. I blame too much adherence to media that skews to the extremes. It's so odd that we've never had so much choice in all of our lives, and yet people are self-selecting and spending time with only the like-minded. I know so many people who, on the Wednesday after the most recent election, were just bewildered by not only the fact that President Obama had been reelected, but by the margin of his victory. And the answer is because they'd been relying solely on Drudge, Rush, and Fox for their information. And I'm not only blaming the right in that regard. A lot of that goes on the left, including where I'm on MSNBC. So change the dial is what I tell people. And money's a factor. I don't think they're in town now. They ran home after last night. They raise all that money to get a job that they're only in town Tuesday, Wednesday, Thursday. Living in Washington means you're in a flop house on Capitol Hill with an ideological twin. Nobody's having a cocktail together. Nobody's breaking bread together. And, it's easy to demonize when you haven't socialized. Those are my four: hyperpartisan districts, gerrymandering, closed primaries, huge factor. I published a piece not long ago, and I was trying to give good advice to the Republican Party. You got to dilute the fringe factor. People have lost sight of the fact that political parties exist for one reason: to win, not to become ideological vessels. And closed primaries where you're putting forth Christine O'Donnell and not Mike Castle, where Aiken, where Murdoch, where the guy in Alaska, they can win a battle, but they're going to always lose a war. But that speaks to the role of a closed primary. And then finally, and I'll stop, Mike, is Robert Reich wrote something very effective in the Times or the Journal recently where he said, why is there so much incivility and hostility? His word was bile. And he talked a lot about social media, the anonymity, the ability to go on the internet and say nasty things and not have someone see who you are, I think is also a factor. So it has me very concerned with how we've gotten this way, and I think it's very complicated and without a single solution. California, on the issue of gerrymandering, is doing something right. California has professionalized the boundary process. California now has implemented a top 2 system. I like it, where it doesn't matter what label you have, but you're going to have to compete. So.
Literally, we're actually over in time. So, question, but just a question very quickly.
Given what you had said about the stalemate in Congress or lack of political will to come up with a new formula, a lot of attention has been focused on Section 3 of the Voting Rights Act, which we haven't really talked about a lot here. And I was just wondering if you could comment on, Section 3 allows jurisdictions to be bailed into preclearance based on a finding of intentional discrimination. I was just wondering if you could talk about, the utility of Section 3 and whether you think that it will be an effective strategy, is it a good strategy, will it be a meaningful way to safeguard voting rights?
You're going to have to tell the audience what Section 3 is, because I think most people don't know.
So Section 3C is a piece of the Voting Rights Act that allows a federal court to bail in a jurisdiction. It could be a county or a state, whoever is the defendant in that case, to bail them into preclearance. And they need to, once they're bailed in, after a showing, as the young lady said, of intentional discrimination, to pre-clear, as they would have under Section 5, any voting changes before they become enforceable. And to answer your question, I actually think, as you know, as your question shows, that there's been a really renewed interest, obviously, in Section 3C after the Shelby decision. In our Texas voter ID case, we've brought a 3C bail-in claim. We're trying to bail in the state. In the Texas Section 2 redistricting case, which we're not involved in, they're also trying to bail in the state of Texas there, and I believe that the Department of Justice has sought bail-in remedy in North Carolina as well. I think it's hopeful to get some of the worst actors who have live cases right now or who will imminently have live cases based on voting changes that they make soon or have recently made, but it's definitely not a substitute for Section 5. It's not a substitute for Section 4B. It's very, very difficult, costly, and timely to bring Section 2 litigations, which are what the basis of the 3C remedy would be, or a constitutional claim. And it would require so much work. It requires these showings of intentional discrimination. And I just don't think it's a substitute for those reasons. It takes a long time to get bail-in. In terms of how likely it is that any of those bail-in claims will work, I think that they're all meritorious. But frankly, before the loss of Section 5, we didn't see a lot of 3C remedies being attached to lawsuits. I think that the biggest one was in the 90s in Arkansas. That entire state was bailed in for a period of time. And that is pretty much the only opinion that we have written from a federal court that looked into whether 3C was an appropriate remedy and then in fact ordered it.
Rare moment. I agree with Natasha.
Not a solution. Last question.
I wonder why, I wonder why you all have to look at certain facts, but I guess I'm really with it.
I can't hear you, I'm sorry.
It's an awkward question to ask, but I worked at the Department of Justice for 8 years in the voting section. And when you talk about, for example, the partisanship, how come you don't lay some of the blame for that at the feet of the Voting Rights Act and Section 5 in particular, and how it was interpreted to require the creation of racial candidate of choice districts, which at the same time cleansed surrounding districts of core Democratic voters and led to both more right-wing and more left-wing candidates. And when you talk about, we talked about perhaps there's a little bit of myopia about voter fraud. Well, isn't there also a little bit perhaps of myopia about voter ID, which is wildly popular, including with minority voters, to the rate of about 60%? In other words, more minority, well, I can't say that, but I was going to make a comparison that doesn't fly. But 60% is a huge margin for any public policy issue. And, people like to refer to Europe when they're making a point. If they're making a point about the death penalty, they like to say, in Europe, they think the United States is barbarian, and they do on the death penalty. They don't refer to Europe when they're talking about the exclusionary rule, which Europe doesn't have. But this is another case. They don't refer to Europe when they're talking about voter ID because they think we're insane. In continental Europe, in Germany, in France, they have universal IDs and they're photo IDs. So I guess I apologize for ranting, and I guess that's what I'm doing. But I guess I primarily heard one side, except from Ms. Thernstrom, and there is another side. And another point I would make is one made by the Supreme Court.
Could you identify yourself, by the way, because I probably know you, but I don't have the right glasses on.
My name is Robert Popper.
Oh, right. Hi.
Hi. Well, with respect to the evidence before the Congress, it's quite right that there was a 7% minority registration rate in 1965 in Mississippi. Today it is 76%, from 7 to 76%, and white registration in Mississippi is 70%. Do you know who should be bailed in? Do you know who has a terrible registration rate for minority voters? Massachusetts. Could the people in this room live with Mississippi not being covered by the Voting Rights Act and Massachusetts being covered?
And could Massachusetts live with that?
So, anyway, these are the variety of points I wanted to make. No question.
Yes.
But I thank you, by the way, because obviously I agree with everything you've just said.
As you can see, this is an issue that brings out quite a lot of difference of opinion. But it's no accident. Obviously, there's nothing more fundamental than the right to vote. And secondly, there's nothing more fundamental than not to be discriminated against. And the Voting Rights Act brings these two principles together in a needless to say, a politically charged atmosphere. It goes to the core of who we are as a country and who we think we ought to be. And the Shelby decision takes one pass at this, but it's clear that it's only the first of what will be other decisions coming down in the future. And it's part of the state of our society, as Michael says. The political polarization in our society, it's visited here in a debate about some of the most fundamental legal issues facing our country. Anyway, I really do want to thank Michael, Natasha, and Abby for what has been a spirited debate, including our audience, who has been equally as spirited on these issues. But let me give a round of applause for all of you. Thank you. And thank all of you for coming, and I look forward to future Penn in Washington events. Thank you all.